I read the emails yesterday and I couldn't stop laughing because the emails were so funny. Like, if you guys ever worked in like mostly like an office environment, you know how you have to be kind of like cordial with people. There's some passive aggressive to it. This is like a whole different level. It's not even passive aggressive. It's just like direct attack. It's pretty fucking hilarious. Crap. I love snarky emails. Do you guys ever watch Camille's interview? So Camille's interview, if you haven't watched it yet, she did an interview a couple days, or sorry, it was probably last week, I think. She did an interview last week with Gayle King on CBS Morning. And, you know, I don't know if you guys realize, but like a lot of the attorneys on Johnny Depp's team were pretty fucking young. Typically, if you see like a high profile case, you know, you see like a bunch of like dinosaurs that's representing because they have a lot of experience under their belt. But for Johnny's case, I was actually really surprised that like, oh my God, like he actually entrusts like young people. That is really fucking cool. And then you find out that Samuel Moniz, he was one of the junior attorneys. He's 32 years old. Oh, I forgot her other name. The other one was like 35 years old. You guys know Camille's like 38 years old. And of course, like they were overlooked by the senior partner, which was like Ben Chu. But I thought it was really cool that he had young people on his team, because I feel like most people, you know, if they're going to be in a high profile fucking lawsuit, they're going to be like, oh, I only want people with experience. I only want like old people, you know, they don't want like young people, fresh people. But I thought it was really cool that he fucking gave him a chance. Oh, is this the one? Oh, okay. Yeah, this is okay. Oh, we could start with this email chain. Let me tell you something. I think the spiciest of them all, though, is definitely Ben Chu. Ben Chu is really fucking spicy. But, you know, these emails are, although we're getting like sort of the full chain, we don't know the prior interactions between all the lawyers before, because it's possible that, you know, Ben Chu may be this spicy because there must have been something that happened between him and Elaine prior, right? But yeah, I don't know, man. They're pretty fucking... Yes, Jessica Myers. Thank you for remembering her name. Yeah, she's Jessica Myers. She is the one that was like 35 years old. Sam Moniz was 32, and then, or is. And then we all know that Camille's like 38. I'm not sure BBC remembers how many seasons there are. They did confirm a new season, about a week ago. Gotcha. Yeah, that's why the Judge Ascarati was like, you know, Ben Chu, you're a snarky guy. And I was like, oh, you know, I didn't think he was that snarky during the trial. But it's because Judge Ascarati, you know, she was privy to some of these email chains. Whenever they had to file a motion, they would attach these email chains. And Judge Ascarati was probably like, damn, this is some, they fighting each other right now. It's a battle. Well, let's start with Samuel A. Moniz. Oh God, this is so funny. Okay, let me think. Do we want to do voices for this? I don't know how would I do Elaine's voice? Elaine's like spicy mayo, Sriracha. All right, y'all, we're jumping to June 2nd. This is from Samuel Moniz. Again, he is the attorney for Johnny Depp. 32, well, he must have been 31 at the time, roughly, and he is a junior attorney, I believe. I don't know that's his exact title, but I think later on, Ben Chu refers to him as like a junior attorney. All right, he writes this. Elaine, we would like to set up a call in the next week or so to discuss a number of pending issues, including the sufficiency, completeness of Ms. Heard's court order production this past Friday, Ms. Heard's responses to Mr. Depp's 7th request for production, Ms. Heard's responses to Mr. Depp's 4th set of interrogatories, and Ms. Heard's, I gotta put on my glasses, I can't fucking read this, and Ms. Heard's ongoing privilege objections with respect to our communications with Eric George. I was trying to look into the Eric George thing. Who's Eric George? Is Eric George a previous counselor for Amber Heard? Because there's also this like really long deposition transcript that was, I think it was like 100, 200 pages long of Eric George. I haven't read it yet, so I've just been lazy. Y'all know who Eric George is? You guys can just fill me in. But based on the emails, it seems like it was like either her previous attorney or something like that. I don't know. Because they kept talking about client attorney privileges. Amber was like, I just want to move on, but this whole aftermath just shows how desperate she is to stay in the public spotlight. Says Kay. But we can just recap it really quick. So we talked about Johnny Depp's already. Johnny Depp did NFT, made money, donated to Children's Hospital. I think he like donated like 800K, right? And then artwork, made millions off of that. New album came out, did a tour. Got the other lawsuit drop with Rocky Brooks, Amber Heard. used to be a stripper or something. I think like Elaine said in one of these Unsealed docs. Oh, she sold her house in the desert. Book deal. What else is there? Oh, it's just like so much random shit. I'm doing good, Raw. How's it going? Hello, hello. Former attorney, right? Okay, so I wonder, is he really... What was important about him, I guess? I didn't read the deposition of Eric George. I guess maybe one day I'll read it. Maybe I'll recap it for you guys. Amber did used to be a stripper, don't know why it matters. I think it's just because it's a shocking headline that you see on YouTube, whatever. I didn't give a fuck about it either. But yeah, it's just one of those things where it's just like, oh my god, it looks shocking. And then people click on it. So it's probably for the clicks. But yeah, I don't know. Nowadays, like, that doesn't really matter. I guess it's just like shocking. But I do know that Johnny Depp used to reference her as like a... What did he used to call her again? He called her a something stripper. And I used to wonder why he called her that. But now we know the context of it, I guess. Oh yeah, she was offered a porn deal thing. But I mean, obviously that was probably the publicity stunt from the company that sent her that letter. Because they were like, oh yeah, we can direct $10 million to the Children's Hospital and the ACLU and then stuff like that. And then like get the letter on there. Oh, floppy fish? This is Sam. We also understand you have a number of discovery motions planned and would like to meet and confer with you regarding those as well in an effort to avoid motion practice or at least narrow the issues to be resolved by the court. Please let us know some convenient times this week or next week for a call. Thank you. Best, Sam. All right, here's Elaine. Oh, wait, no, it's not Elaine? Oh, it ain't Elaine. Okay, so Sam sent this message on June 2nd. It gets forwarded to Camille Vasquez, and then it gets forwarded to Ben Chu on June 4th. So this is like 2 days later. This is from Ben Chu. Elaine, you failed to respond to our request for a meet and confer. Please see below, and defendant is in contempt of the court's most recent order, compelling her further production of document. You misstate the status of discovery to the court, and if you file a motion today without properly meeting and conferring, something which Chief Judge White, so that was the previous judge that was handling all the pre-trial stuff, I believe, and then it went to Judge Ascarati. Chief Judge White found to be the case previously. We will immediately seek sanctions. This is getting tiring and is a terrible example to the jury. Ben. This is getting tired and is a terrible example to the junior attorneys, Ben. So the junior attorney must be Sam Moniz, and I guess Jessica. I don't know. I think at that time, Camille must have been associate attorney. I think. Oh, here comes Elaine. Elaine's about to respond right now. Elaine. Ben, your series of emails today suggests that you're having a really bad day. I have a hearing this afternoon, but I will collect all the evidence of a prior meet and confers on the issue and respond in detail to your incorrect statements when I have the opportunity. As to Sam's email, he sent out many emails to many people in a short period of time, apparently at your direction, demanding many things from everyone. No one on your team has even made the slightest attempt to convey what you believe is deficient or in contempt of court and what any of your issues are. Sam's email does not even in capitalization, even one specific allegedly deficient response. I genuinely believe the email by Sam, followed by yours below, are sent solely for the purpose of harassment and delay. That's an accusation right there. After securing the ruling from the court not to stay in discovery, knowing we have 6 motions in the queue, which we have patiently waited to place on your docket until the court was able to hear the motions. You succeeded in preventing the stay, so now our motions, covered in meet and confers more than 3 months ago, are ripe. Oh God, for resolution. Elaine has a very interesting choice of words. I think at some point she says pounded out, and her saying ripe, I don't know. I don't know, man. I'm just getting too much visuals in my head right now. I suggest you read your emails, time records, and notes before further claiming we have not held genuine meet and confers on the first 6 discovery topics and confirmed they were ripe for... Stop saying ripe, Elaine. Stop it. They were right for bringing motions. If you believe you have informative any... I can't stop laughing. Okay, hold on. Let me reset. Let me All right, I'm reset. Okay. This is not as bad as the pounded out thing. If you confirm that you have not, please do so, and then we can follow the process of trying to resolve the issues and schedule a meeting and confer. Elaine. Damn, not even like a best. Yours truly, sincerely, Elaine. All right, who's this? We're back to Sam. Sam. All right, Sam coming in a little bit spicy, so Elaine sent that on June 4th. Sam sends this. Damn, man. He makes the email. Oh, it's talking about like, okay, a couple hours. All right. Elaine, I am quite puzzled at your characterization of a standard request for a meet and confer as harassment. If you were concerned about what a phone call with us would cause undue delay, you could have responded promptly, set the meet and confer for the week, and had it done by now. Dude, this is a spicy fucking email. This is the email you typically don't want to write in like corporate America, but these are between lawyers and like different law firms and stuff. If you're writing this email within your company, you're gonna cause a lot of conflict with your other co-workers. All right, let's keep reading. Instead, your email below suggests that a deliberate decision has been made, and not for the first time, to simply ignore a request to meet and confer and proceed full steam ahead with your motions without making any genuine effort to determine if a compromise is possible. I told you guys, these emails are fucking spicy. Spicy! Elaine sounds like a snooty Karen writing an email to corporate and tricking like cashier. The background music. Wait! I have background music? No, let me turn off the background music. Where is the background music? I don't know which tab. Guys, I have like a million tabs up. I don't know which. Okay, let me turn it off. I'm turning it off. Okay, we're not reading no love letters or anything like that. All right, we're reading spicy emails. Spicy. They're done. Okay. We will certainly be pleased to send you more detailed summary of our concerns with Ms. Heard's discovery responses in advance of a confer and meet and confer. In brief, however, our concerns cannot possibly come as a surprise. Ms. Heard served blanket objections to our last set of interrogatories. Ms. Heard served blanket objections to the majority of our last sets of RFPs. And Ms. Heard appears not to produce all or any documents that are ordered to be produced following the last motion to compel, despite requesting an extra 30 days for that production. As for your representation that the meet and confer process, so remember the meet and confer thing, they're going to fight about this a lot, okay? Just remember this. The meet and confer process on your proposed motions was completed 3 months ago. We respectfully disagree. During our meet and confer 3 months ago, you specifically indicated that you intended to reassess a number of our requests and would undertake to consider whether some of them could be narrowed to address our concerns. We never heard back from you. I will link these emails. I'll push a video out and then I'll link the emails in there, or I'll put it in my Discord or something. So you guys, it's 132 pages, okay? If you guys feel like it, we're gonna go over this email, this doc, and an email and another doc. But it's not 132 pages of emails. It's a bunch of other shit before it, but we're not gonna read that. We're just gonna read just the emails. However, we in fact assess some of our responses and believe that a compromise should be possible on at least some of the requests at issue, warranting further discussion before the court is burdened with motion practice. Again, we invite you to provide your availability next week to meet and confer. Thank you. All right, let's see if they try to schedule a meet and confer. Let's see. Elaine responds back. Yes. This is when you know shit gets real, because Elaine does the bullet points and then she responds to each one. I actually like it when people do this, just so they know exactly what they're responding to. All right. Elaine writes back, so she had a good weekend. She writes back the following Monday. So she enjoyed her weekend. All right. Sam, I am disappointed that your email confirms my suspicions that the sole purpose of the email earlier and this one was to quickly create a discovery issue, or two, to rush to file motions to attempt to prevent us from filing the motions we have had in queue for several months. Hey, Joan, how are you doing today? Joan Morrison, thank you so much for the 5. Someone actually commented this on my YouTube video. You cannot bring up new evidence during the appeal. It's only what's already been in the court. So yeah, that is what someone said, and you know what? That sounds about right. So no new no new evidence is to be introduced. The only thing would be like, yeah, because what they do is they look at Judge Askarati and to see if she actually, I don't know, covered it fairly and there's any like bad faith in it, I guess. But yeah. I don't know anything else about the appeal, but that is what I've heard. I am going to address each of your points below separately. Okay, so like I said, guys, when they have the bulleted points and they're addressing it separately, that's when you know shit really gets real. All right. This is what Sam said. Ms. Hurd served blanket objections to our last set of interrogatories. Elaine, it is obvious you never even looked at our objections to your fourth set of interrogatories before writing this email. Damn, dude. See, it's like at this point, when you're starting to do like ad homs and like attacking people, people are just gonna get fired up. You're not even gonna, it's hard to have a meaningful conversation back and forth, especially in emails, because when you write an email, the person that is the recipient of it, they're gonna read it in even more of a scathing tone. And it sounds scathing as fuck. So I feel you're just gonna have a lot of like, it's a lot of bad feelings in it. But okay, let's carry on. The primary objections upon which we relied and stood were that Depp has already exceeded the permissible number of interrogatories under rule blah 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 blah. If you contend you have not exceeded the permissible number, including parts, subparts, please tell me what your count reveals and how you arrived at that court. So they're going to fight about this number of interrogatory thing. They said that Mr. Depp exceeded 30, and I think 30 was the max, but then team Johnny Depp's lawyers are going to be like, well, there was only 18. So I wish they clarified the number of interrogatories like right here, right now, because I feel like that could have solved a lot of things, but they're going to battle back and forth. Then we may have something to discuss, although I think the counting is pretty clear. See, here's the thing. If you're going to say the counting is pretty clear, then fucking include it in your email. Have evidence to back that up. Don't just say it's pretty fucking clear. Ms. Hurd served blanket objections to the majority of the last set of RFPs. Note, this is the exact phrase you used for your first point, suggesting this was written as hastily and without ever looking at the objection or responses. Moreover, what does it even mean? I can see Elaine saying this in my fucking head. We both have general objections and specific objection discovery. Which one of yours do you consider to be valid? Which do you consider to be blanket? This is hardly a description warranting a meet and confer. If you have a specific request that you believe we have incorrectly objected to, please let us know. We will review. And if we disagree, we will be happy, doubt that, to discuss in a meet and confer. Ms. Hurd appears not to produce any documents that have been ordered to be produced following the last motion to compel, despite requesting an extra 30 days for that production. Here's Elaine's response. This one is the most outrageous of all statements. First, your admission that Ms. Hurd appears to not have produced any documents says it all. You never even looked at our second supplemental responses or the documents produced, or you'd have known the statement is false. Apparently, however, you conveyed this false statement to Ben Shu, resulting in his claim that we were in contempt of court. We take the accusations of this nature very seriously, and especially when it is the obvious on the face of your email that you never, ever even reviewed the responses or the early responses or the, in bold, in excess of 1 million documents we produced our responses to these RFPs. This is while you claim we have not produced any documents. We even provided the bait timestamps, which you have refused to provide us in any of your discovery pleadings. Take the time to review our responses, both the supplemental and second supplemental, and be sure to review all the documents we provided. I love the use of the capitalization, the use of bolds. Oh man, this is an angry email right here. If and after you've taken the time to review these, you still believe we have not produced responsive documents in our possession, please let me know which request and why you believe this. We will review and consider, and if we disagree, we'll be happy to schedule a meet and confer. All right, next bullet point. All right, next point. During our meet and confer 3 months ago, you specifically indicated that you intend to reassess the number of requests and would undertake to consider whether some of them could be narrowed to address our concerns. We never heard back from you. I've already addressed this to my email to Ben and cited record evidence contradicting you. However, you are correct that I indicated that with respect to some of the requests for admissions, I would reevaluate in light of how other motions turned out, as many may be mooted. You conveniently left out the words for admissions in your email. We do not intend to bring any motions to compel on the request for admissions because we believe other motions need to be resolved first and may resolve the issues with many of the requests for admissions. Next bullet point. However, we have in fact assessed some of our responses and believe that a compromise should be possible in some of the issues, requested issues, warranting further discussion before the court is burdened with any motion practice. Elaine, Excellent. Then you should be able to provide us by COB tomorrow with a response to the Tracy Jacobs issue. This is a power move right here. She's demanding something. She's like, your deadline tomorrow. All right. I want it tomorrow. I don't know if that would even be, if that's even doable, you know? I don't know how big of an ask that is. It might be. Paperwork is time consuming. And the 10th RFPs that you are now withdrawing your objection to, when you will be able to provide the documents and enter into the consent orders reflecting these new positions by you, and for the 11th RFPs and the 12th RFPs by Friday. Damn, she's demanding all of these documents. She's setting these timelines. Whew, people don't like that, being told what to do. With a consent order by next Tuesday. I'm glad you're willing to resolve some of these after literally months of us trying without any success. In the future, I would ask that you take the time to look at these documents and pleadings we have sent you before making allegations and accusations that are demonstrably false and would have been obvious to you if you had any simply taken the time to review before writing them and sending emails in the nature of this nature. Thank you for your anticipated consideration in the future. Elaine. Let's see how Sam responds to this email. Damn, this is the email you get on a fucking Monday. You guys ever go into work on Monday and then you get a fucking email, a shit email on a Monday, and you're just like, I don't want to deal with that. Why? So this was sent on a Monday at 11:20. Ooh, right before lunch break. You know you can't let this fly. You can't go on your lunch until you address this email. Otherwise, it's probably not going to sit right. Let's keep reading. Hi, Rain. Hi, Lena. How are you doing today? Hi, Annie. How's it going? All right, Sam. Oh, damn, Sam writing a damn essay here. All right, Sam. Sam writing a lot. Okay, I am going to, this is from Sam. Okay. Elaine, I am in receipts of your emails to me and to Ben Chu early today. First, I take issues with the repeated insinuations of bad faith in your emails over the past several days. It is noteworthy that you have gone far as to edit the subject line of your responsive email below so that it reads, an exclamation mark, exposing your true motivations for the emails requesting a meet and confer. Who the fuck does that? What is that long ass subject line? Oh my God, she is so funny. So she does this thing where she edits subject line, which I think is funny. So, Det V heard, exposing your true motivations for the emails requesting a meet and confer. She wouldn't edit the subject line. That's so funny. But she actually has a response to this as to why she does it. It's for her own mental notes. But like, it's just like, it's fucking weird, man. It's like, it's unprofessional. But, you know, these two, they go at each other. So, man, I want Sam to write my emails for me from now on. Shoot. Sam be spicy as hell. All right, let's go. So, Elaine does this really long email subject title. To say that this is a bizarre response to a commonplace request for a meet and confer is an understatement. Oh, Lordy. I am not sure why you now seem to feel the need to litter your professional correspondence with such accusatory language, or what you think is hyper-aggressive language accomplishes. But your insinuations are baseless, pointless, and, quite frankly, offensive. The needlessly aggressive tone and content of your emails is even more puzzling and inappropriate because you have, in fact, failed to adequately meet and confer regarding your proposed motions, as detailed more fully below. So first off, we got this whole ass paragraph right here that is just boom, boom, bomb, bomb, bomb. Like, this is spicy right here. Okay, this is crazy. Elaine comes from a family of lawyers. Her answers are rolling in their graves. She does. Yeah, I think her daughter's works in our law firm too. Just a reminder, Sam is 32 years old. Elaine, at this point, she is, how old is Elaine again? I think she's like in her 50s, maybe 60s. I think she's in her late 50s, maybe early 60s. But when Elaine gets these emails from a junior associate, I'm sure to her, she probably thinks like fucking insulting, you know? Because like, it's not even just like a partner or someone of like a higher senior status. It's like writing her these scathing emails. It's a junior associate. And you got to remember too, because, you know, egoism is at play here, right? You got to remember, who is attached to these fucking emails? We have a whole fucking essay of like CCs here, okay? We got Ben Roddenborn is on these emails. Adam Nadelhoff is on these emails. We got Camille Vasquez. I think CBC Law, like Clarissa, David Murphy, and who is the other dude? There's another. Oh, he's on in this email right now. But I think some of the lawyers on this email I think they're like, they're lawyers who are mediators between the two law firms. I think that's who they are. And then we got M. Bretterhoff right there, which I think is probably, I think Elaine referred to her as her daughter, I think. We have some other associates on here. So it's a lot of people that are seeing these fucking emails. It's not just like between you and another person, it's everyone else. So this is, we over here pump like, or they're over here like, like pounding their chest right now. Cause it's like who can write the best email? Oh, her daughter's a paralegal. Oh, okay. That's cool. All right. Damn. So we go into the spicy part, and it probably just gets even more spicier because here's Sam over here. He's going to battle out with Elaine. Let's keep reading. It is our hope that our counsel for the parties will be engaged in a cooperative, productive, and respectful conversation by phone. That's what I'm saying. I'm like, why can't y'all just call each other? But I feel like the reason why the emails need to be written is because it has to be documented probably. Because if it's like done by phone, you can't record phone calls maybe, and it's too messy. I don't know. I feel like they should do phone calls, have the transcripts written up, and I don't know. Because like email is just, at this point when the emails start getting this spicy, I feel like you're not getting much done. People are just going to get really defensive. Okay. You don't want people to get defensive because shit ain't going to get done. To that end, I invite you for the third time and let us know your availability this week to meet and confer by telephone. We will do our best to accommodate your schedule. Okay. So I like this. I feel like this is like maybe like a young person thing. Young people, I feel like they just want to get things done ASAP and like, let's just do it over the phone. It's so much easier. Let's stop writing this fucking emails. It's a waste of time. Phone, let's go. But anyways, let's keep going. In the meantime, please allow the brief below to briefly address some of our disagreements and the contentions in your prior correspondence. In response to Ms. Heard's corrected 10th RFPs, we respectfully disagree that you've adequately met and conferred with respect to the 10th RFPs. A meeting confer was briefly conducted with David Murphy from your office on about February 3rd, which primarily focused on differently. Wait, this is spicy. Okay, hold on. Damn, this whole thing is really spicy. Give me 1 second. February 3rd, 2021, which primarily focused on completely different requests, and a second brief conversation, which was held by your California co-counsel, Hazel. Later in February, I do not consider any of these conversations sufficient to satisfy your obligation to meet and confer. During our meet and confer on February 3rd, Mr. Murphy briefly discussed our general objections to the 10th RFPs, but to the best of my recollection, did not delve into the specifics of the request in any meaningful way and made no serious effort to explore a compromise on any request. Damn, Mr. Murphy got thrown on the bus. Similarly, although we briefly discussed the 10th RFPs with Ms. Pangan, amongst numerous other issues, there was no meaningful discussion of any potential compromise, as Ms. Pangan's subsequent email on February 19, 2021 concedes. We specifically offered to meet and confirm any proposed narrowing of the request. Ms. Pangan apparently did not have the authority to offer any meaningful concessions without checking with you. And I do not believe you ever proposed any narrowing of these requests or otherwise followed up. If I have overlooked a substantive proposal from your office, please forward to me so that I may review it. That also raises another issues on these meeting confers. Quite frequently, we find ourselves talking to attorneys who seem to lack any authority to negotiate anything that does not amount to a complete surrender of our position. Mr. Murphy, Ms. Pangan are undoubtedly fine attorneys, but I have consistently come away from our conversations with the impression that all decisions on your team, no matter how trivial, are required to be run through you, in which case a meet and confer with anyone else seems to be an exercise in futility because no one seems to have authority to compromise. Okay, so I get what Sam is saying here. Sam is like, we did these meet and confers with other attorneys, but what's the point of doing these fucking meet and confers when they didn't have the authority to make decisions anyways? It all comes back to you. So why the fuck do we not just meet and confer with you, Elaine? Why? Okay, I get his frustration. All right, let's keep going. In short, we do not believe that there has been a serious engagement on your part in connection with the substance of the 10th RFPs. If I remember correctly, Elaine's law firm is family owned and operated, right? It's probably like a really small law firm. I wonder if she's just like inundated with like other cases as well, and this is just like too much load for her to handle. Oh God, why did I say that? That sounds weird in a sentence with Elaine. Okay, erase that statement. You did not hear that from me. too much work for Elaine to handle. There you go. That lack of engagement is all more troubling, considering the patently overboard and harassing scope of many requests. By way of example, the 10th RFPs include the following requests. All right, we're not going to read that, blah, 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 blah. And you have asked for a very wide range of documents from multiple other litigations involving Mr. Depp, including litigations with his former attorneys that raise substantial privilege concerns. The overbroad and irrelevant nature of these requests is apparent on their face. Yet we have never received any proposals from you to narrow the scope or to meaningfully respond to our substantive objections. Man, this must be so frustrating. You have a trial that's coming up, there's a deadline, and you're trying to get all this done before that trial happens. And you're going back and forth, especially in emails with another law firm. Like, this sounds like a fucking headache. People who are working in a law firm, bro, you guys, I don't know how you guys do it. It's a lot of work. Oh, thanks, brain. Nonetheless, we believe that a compromise on some of these requests ought to be possible, particularly if you are prepared to moderate your positions even slightly. For instance, we may be able to reach an agreement on a reasonable subset of documents from other litigations that can be produced, provided there's a clear nexus between such documents and the issues in this action. You can articulate an explanation of the relevance. We are prepared to further discuss those and may be able to reach agreement to produce responsive documents. All right, next response. We are unclear about your specific concerns are with respect to these RFPs. However, to the extent that you are basing your contention that we have sufficiently met and conferred in a brief conversation with your California consul, I will note the same concern I've already noted above, that other than you, no one on your team seems to have the authority to make concessions or meaningfully negotiate. There's always like this phrase, never take a no from someone who can't say yes. So if you're going to like a store, you want to return something and the maybe like the sales rep is being unfair to you and they're like, oh no, you can't return it. Well, it's because that person doesn't have the authority to say yes because they don't have the manager override. So, if it's something really serious, always ask for the fucking manager, Don't let them step all over you. I can imagine the feeling when Depp won. It was a win for the entire JD team. I know they're like, finally, yes! After years and years of back and forth. So yeah, it's crazy. It is crazy. You and I specifically discussed 12 RFPs in March. During that call, you specifically represented that you would undertake to modify or rethink certain requests. For instance, you commented that you agreed at some point of the interrogatories RFAs your predecessor counsel had served may have been inappropriate or tangential to these issues and agreed to consider revisiting requests such as RFP number 7. Also, here's another thing. Since Elaine is like the head of her law firm, I think, right? She's probably the head of her law firm. She probably has so much shit doing. Doesn't she have any paralegals that could handle these correspondence or junior attorneys to handle the correspondence for her? I feel like, or is she one of those people you think that like doesn't like to, one of those people who doesn't like to, that fucking word? I can't think of it right now. Delegate her work to other people because she feels like she needs the control. Because I'm like, like Brown Rudnick, they over here, they're like, okay, here, junior associate, you can handle this. But Elaine is, I don't know, man. This, how come Elaine doesn't have someone else handling her emails? Okay, all right. Maybe she just wants to be hands-on with everything, It's a very important client of hers. She doesn't want to fuck it up. You specifically represented that you would undertake modifying or rethink certain requests. I think I read that. Blah, 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 blah. I do not believe you ever follow up on these points. If you believe that I have missed a substantive email communication, substantive, I hate that word, from your office in which you do so, please forward to me so I can consider it. On a side note, I referred you to the following comment in your email to me below. Oh my God, this is so funny too. So, this is what Elaine wrote. You are correct, and I indicated that with some respect to our requests for admissions, I would reevaluate in light of how the other motions turned out, as many may be mooted. You conveniently left out the words for admissions in your email. This is what Sam says. When drafting your email this morning, you apparently forgot that you also indicated that you would revisit the RFPs. So look at this tit for tat right here. Oh, Lordy. Next, addressing Tracy Jacobs. In case, if you guys forgot who Tracy Jacobs was, she was a former talent manager. Is that what she's called? Former agent, maybe talent manager / agent for Johnny Depp. He fired her and she testified on behalf of Amber Heard. Your arguments regarding the Tracy Jacobs depositions are unfounded and once again have not been preceded by appropriate meet and confer regarding the substantive relief you are apparently seeking in your anticipated motion. Your concern over the purported inability to authenticate Ms. Jacobs' email is easily remedied without motion practice. Indeed, there are a number of ways in which you have the ability to authenticate Ms. Jacobs' emails. To state the obvious, Ms. Jacobs was not sending emails to herself. She was emailing other persons, such as Edward White, Joe Mandel, both of whom you've already subpoenaed for the deposition. You can authenticate those emails through other witnesses on your deposition list. It is unclear why you believe you need a motion to authenticate these documents, but we can certainly further discuss the issue with you. Oh my God. Junior associate attorney schooling a fucking partner. Holy shit. Let's keep going. Let's see if it's, what else he has to say. We've previously addressed your other complaints about the timing of the Tracy Jacobs documents production on several occasions, and have explained the documents were produced promptly once they were identified as potentially relevant to this action, although it is not clear that they're even responsive to your request. Next, Mr. Depp's anticipated motions. Finally, with respect to our anticipated motions, please allow below to briefly summarize our concern. First, we did in fact review your response to the fourth set of interrogatories. You did not respond to a single one. We believe that your objection that Mr. Depp has served more than 30 interrogatories is simply incorrect. We are, however, prepared to consider your arguments in defense of that position in the course of our meet and confer. Second, we similarly reviewed your response to our last set of RFPs. You objected and failed to respond to 10 out of the 12 requests. Again, we do not believe that any of your objections are well taken, as these RFPs are all directed to the core issues in this case, including and especially the authenticity and the truthfulness of critical documents purportedly supporting Ms. Heard's claims of A. Third, at the hearing on Mr. Depp's recent motion to compel and his subsequent order, the court overruled all of Ms. Heard's objections to the discovery at issue, with the exception of 3 requests. In the subsequent document production, however, Ms. Heard failed to produce categories of documents that are clearly called for in the motion. By way of example, Ms. Heard did not produce any communication with Eric George, despite the court's rejection of Ms. Heard's construction of scope of the waiver of the... In fact, with the exception of a couple of tax returns and the productions you recently made appears to consist of documents that have nothing to do whatsoever with our recent motion. We look forward to providing a date and time. Oh, to your providing a date of time to meet and confer. So I think at this point, this is like the 3rd or 4th time that Sam Moniz has asked for a date of time for a meet and confer. Meet and confer. He's like, hey, meet and confer, meet and confer. Let's do it. Meet and confer. And then Elaine's like, essay response. All right. This email was written, was it after lunchtime, Sam? Did you get to eat lunch today? That's a long ass email. Damn! 12:59 a.m. Holy shit. So Sam wrote this. Damn, it was up late. Sent it to Elaine at like 1 a.m. All right, let's see what Elaine says. June 10. This was sent on June 8. Okay, at 1 a.m. Elaine responds back. Where is it? She responds back, man, they need time. If you guys notice, the correspondence is getting longer and longer and longer because they're writing essays to each other at this point. Elaine responds back roughly a day or two later. Sam, thank you for finally admitting that we have held meet and confers, that your objection is to the quality and experience of our lawyers, and that you perceive the discussions as inadequate. Neither negates that we have compiled with the requirements of a meet and confer, which we would thoroughly document it. Okay, first of all, Sam didn't say anything about the quality and the experience of your lawyers. He said they were fine lawyers. He just said that they didn't have the fucking authority to authorize things because it seemed like everything had to go through Elaine. So it's like, what's the point of meeting with them if they can't authorize anything, right? It just seems more of like a time waste. All right, let's see what else Elaine says. I feel like there's a pattern of this already forming. Elaine's studio, I'm better than you, Tone. Everyone on JD's team's like, I'm done with you. Maybe in law school, they need to teach it. Turn your damn microphone on. All right. On the subject line. Oh my God. Okay. So remember how Sam Moniz was like, why the hell are you editing your subject lines? Because Elaine edits a subject line to this. Exposing your true motivations for the emails requesting a meet and confer. All right, let's see Elaine's explanation of why she likes to adjust the subject lines. On the subject lines, if you review emails with me over the past year, you will see that I regularly try to bring the subject line up to the most recent topics on a regular basis, so they identify the subject being discussed. It is good practice, and I wish all attorneys would follow this process. Okay, Elaine, it's not just you updating the subject lines, it's you also being spicy in the subject line by saying exposing your true nature and the reason why you want to do a meeting confer. Okay, that's pretty fucking weird. Next. On your discovery issues, I will again address them each separately. First, we did in fact review your response to your fourth set of interrogatories. You did not respond to a single one. Oh, this is Sam writing this. Okay, so Elaine is doing the bullet point responses again. Okay, let's see what Elaine says. I'm going to skip through what Sam said. I asked you earlier to count the previous interrogatories, including parts and subparts, and let me know what the count was. You ignored my request. The only way a meet and confer would be productive is after you count them and tell us the number that you arrived at. If less than 30, we can meet and discuss in a meet and confer how we have arrived at each number. If you're unable to persuade us, you have not issued more than 30, including parts and subparts, then we can discuss whether we intend to rely on other objections or will respond. Damn, they just need a phone call. Sam's like, hello, when can you do the phone call? Let's do the phone call. Let's do the phone call. Bro, just do the phone call, okay? You guys are going back and forth in the email. This is such a waste of time. Such a waste of time. All right, Elaine's other response. Again, you failed to identify even one request, objection, or why you believe the objections are not well taken. A precursor to meeting and confers is to identify the issues so we can consider them, and if we do not agree, then schedule a meet and confer. Once you have done this, we will be happy to consider your issue. If we don't agree with you, schedule a meet and confer. Is a meet and confer that hard to do? Why is it like, oh, let's fix everything in email first and then we'll do a meet and confer? It seems like if you're having communication issues and you're not coming to an agreement, just fucking meet and confer, right? I don't know. Any lawyers in here? Is it that hard to do a meet and confer over the fucking phone? Oh, lordy. Next. I read and reread this paragraph. I have no idea what you think we have not produced. You reference new communications with Eric George. What exactly are those? Chief Judge Ascarati made clear the privileges were waived for the transaction. While we waived this as a limited waiver, we nonetheless had already produced all the emails and texts. What specifically do you think we possess that we have not produced? Likewise, on the others, what do you think we possess that we did not produce? You may have forgotten that you filed the exact same motion twice, back in February, and you did not take into consideration our 98-page supplemental response and 1 million+ documents. 1 million alpacas, Elaine? Both of which we produced after you filed your first motion. We produced some additional documents with our second supplemental responses that we believe may be responsive. If you have a basis for believing we have withheld documents in our possession that should have been produced, please let us know what you think we have withheld for the basis of your belief and the address. If you do not, there's nothing to discuss. I look forward to receiving a substantive, responsive email that addresses my specific points. Okay. Let's see what Sam says. I mean, I feel like Sam's been doing a good job with like the substantive, responsive emails, you know? But it has a lot of spice into it. Why is she dodging the phone call? Right? Why? Is she stalling or something? Like, come on now. All right, Sam. Here we go with Sam. Elaine, please refer to the letter sent earlier today for a substantive position on the various discovery disputes that have been arisen. We will look forward to your response. In addition, 2 points in your email below warrant brief correction. And correction time. First, your suggestion that we objected to the quality and experience of your lawyers, which you asserted both in your recent emails and in a filing with the court, is an obvious and rather troubling mischaracterization of the emails below. No objections or the quality or experience of your lawyers was stated. We merely noted our impression that the attorneys to whom you have delegated to your meet and confer seems to lack authority to offer any other than take it or leave it position. You have not disputed the accuracy of that impression, and certainly I cannot recall a single concession that was offered and any items addressed in your 2 most recent motions. Damn. Second, your suggestion that we are finally admitting that you meet and confer again mischaracterizes our prior correspondence. We never denied that there's been a couple of phone calls several months ago during some of the discovery was discussed, but those month-old phone calls during which your team offered no concession relevant to the motion you just filed and never followed up on our invitation to propose narrowed request do not come close to satisfying your obligation to confer. That is particularly true given our repeated offers to further confer and the patent lack of urgency for your recent motions. Virginia requires a reasonable effort to meet and confer to resolve the subject of the motion. You are free to argue with your conduct in rushing to follow your two most recent motions while rejecting at least two separate requests to meet and confer in the preceding week was a reasonable effort on your part. We disagree. Woohoo! Oh, Lordy. All right. Oh, man, this is so funny. It goes back and forth. Holy shit. All right. Elaine, Tuesday, June 29th. This is like a month-long email chain, okay? A month fucking long. I want to see Ben Roddenborn emails. I don't think I've seen any emails from him. Sam, you raised a number of issues in your letter not previously raised and which require some examinations of our earlier records and research. Given the motions practice that we've had this Friday, coupled with a brief due on July 7, combined with some significant deadlines in other cases this week and next, the three of our team on vacation, in order to fully examine, prepare for a meaningful meeting confer, we would not be in a position to schedule something until after July 8th. What is this, excuses? I would appreciate your providing us with several dates and times for the meet and confer, July 9 and the week of July 12. Dude, he was like, you provide me dates. And she's like, no. You provide me dates. While you are reviewing your calendars, please let me know if Mr. Depp agreed to Rule 410 examination. Also, if you will agree to consent to additional interrogatories, RFAs. These would necessarily be included in the meet and confer, so I want to raise them for you to consider in the meantime. So I think the Rule 410 examination, if I remember correctly, I think it's that medical examination thing that they're trying to do for Johnny Depp. I think. Let's see what Sam says. I think. Yeah, I think it is. Okay. So if you guys remember, Amber Heard said that her mental condition is at stake because of what she went through with Johnny Depp. She said she suffered from PTSD, blah, 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 and some other things. And so she had Dr. Don Hughes do an examination of her and to confirm these things. Well, when she did this, she kind of screwed herself over because Johnny Depp's lawyers were like, well, we don't know if you can trust Dr. Don Hughes. Like, we don't know who you hired. So we need to do our own independent medical examination of you. And then when they asked for the medical examination of Amber Heard was like, well, if I have to do one, then Johnny has to do one. Well, the court was like, well, no, Johnny actually doesn't have to do it because he never said that his mental condition was at stake. You're the one who kept saying that you suffer from PTSD and whatever else, right? And so that's what we're about to get into right now, right here. And then we're going to see, this actually goes back and forth. And as you guys know, Johnny Depp never had a doctor examining him. But it's actually pretty funny because they were like, oh, yeah, you know, we're going to have Dr. Spiegel examine Johnny Depp. And these are the reasons why he's qualified. He's board certified, blah, 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 blah. And then, like, we remember Dr. Spiegel. Dr. Spiegel, you know, initially he started off as like, okay, this is a guy you can take seriously. But then it really just went downhill because when he got cross-examined, that guy lost his shit, all right? He was so, he became so egotistical, unprofessional, and very, very strange. But anyways. And as you guys know, Dr. Spiegel never actually got to meet with Johnny Depp and to do a full examination of him. Dr. Spiegel just looked at, I don't know, court docs, deposition videos, maybe transcripts and things like that to make his decision. And that's why Wayne Dennison, Johnny Depp's lawyer, was like, oh, you know, the golden rule where you can't really make a psychological examination of someone if you didn't actually meet with them. So just a quick little reminder in case you guys forgot about the trial. Oh, yeah, and through the movies, too. Through Pirates of the Caribbean, through Willy Wonka the Chocolate Factory. Yeah, Phil says Spiegel diagnosed Johnny through his movies. Yep, and then he talked about the one with the earpiece thing. That's Dr. Spiegel. Anyways, let's keep going. Oh, yeah. She fucked herself over because here's the thing. When she had the medical examination done by Dr. Don Hughes, one, Dr. Hughes was not a good witness. She was very unlikable. Dr. Spiegel, also very unlikable. But who was likable? Dr. fucking Curry. So had Amber Heard not done this, there would have been no Dr. Don Hughes, no Dr. Spiegel to make her look bad, and there would have been no Dr. Curry to make her look even more bad. So yeah, she really fucked herself over with that. But anyways, let's keep reading. Sam's gonna respond to Elaine, and damn, same day response. Let's go. Elaine, your response is problematic in several aspects. Most importantly, the sudden inquiry regarding a Rule 410 examination of Mr. Depp is patently inappropriate and strongly suggests an improper purpose to harass and retaliate against Mr. Depp, rather than to obtain any legitimate discovery. As you know, a mental or physical examination is only permitted under Rule 410. in quotation marks, when the mental or physical condition of a party is in controversy and may be ordered only on a showing of good cause. There is no credible argument that Mr. Depp's mental condition is in controversy within the meaning of 410, merely as a consequence of having commenced this action. Indeed, your predecessor counsel, oh yeah, okay, he'll get into it right now, along with your current co-counsel, previously sought such examination. The court rejected that request outright, denying Ms. Heard's motion for a Rule 410 examination on or about November 15, 2019. Yeah, so the other previous judge, I think Judge White, Bruce White, he was the one who rejected this. So it's actually kind of crazy to me that, like, why is Elaine asking for Johnny Depp to be evaluated when it was already rejected by the court? Hello? They already... I'm just so confused why she's rehashing this all over again. I wonder if Roddenborn's, like, rolling his eyes when he heard this, or if he was just like, okay, let's try again. Like, I don't know. This is bizarre to me, but... And I'm sure it's bizarre for the Brown Rudnick attorneys, too, because they're like, dude, we already hashed this out. Like, why are you bringing this up again? Hello? Okay, let's see what else he says. That ruling was clearly correct when made. Nothing has changed since then to justify a renewed request. In our view, any attempt to relitigate the court's ruling on that issue would not merely be unwarranted, it would be sanctionable. Maybe this is why Judge Penny was so impatient with Elaine. Because Judge Penny, maybe she was like, hey, we already made a decision on this. And Elaine's like, but, can we just look at it again? No, Elaine, we're done. Move on. Because I really did get to feel that at the end of the trial, Judge Penny was starting to get a little bit impatient with Elaine, especially when we got the transcripts to the post-trial stuff. I never knew that about John. Explains why Johnny was never looked at. He asked for mental protection from prosecution. All right, y'all. So we go to 410. All right. As you know, we have not previously sought a Rule 410 examination of Ms. Heard. The only reason that we're doing so now is that Ms. Heard has recently placed her own mental condition directly at issue by making the tactical decision to undergo a forensic psychological evaluation by her expert for use in this litigation. In doing so, Ms. Heard made clear that she believes her own mental condition to be directly relevant and also revealed her intention to present evidence at trial of this forensic psychological evaluation from her own mental condition. So see, I'm telling you guys, she fucked herself over by doing this. In fact, Ms. Heard's expert disclosures make plain that she intends to use this forensic psychological evaluation to bolster various of her claims, including her claim that she suffered abuse during her relationship with Mr. Depp, merely by way of example. Ms. Heard's expert disclosure states that her designated expert's evaluation, Ms. Heard, results in the following conclusions. All right, we're not going to read all that, but those are the conclusions of Dr. Don Hughes. And if you ever want access to that, it's all up. It's up here somewhere, but not in this exact document. Maybe it is. Is it? No, I don't think so. Maybe it is. Might be. Given the content of Ms. Heard's recent expert disclosure and her obvious intention to present such evidence at trial, we have no alternative but to seek appropriate discovery to counter that anticipated testimony, which includes a Rule 410 examination. In the alternative, we would be open to discussing a stipulation that prevents Ms. Heard from presenting such evidence at trial, which would likely obviate the need for an examination. But as long as Ms. Heard intends to try to present evidence at trial of a self-serving, forensic psychological evaluation by her own expert, we are clearly entitled to take contrary discovery on that issue. Finally, it is disappointing that 27 days, I'm telling you guys, this has been a month that they've been fighting about this. After I first requested a meet and confer in the email thread below on June 2nd, you're now suggesting we need to wait another 10 days before you will be prepared to participate in a phone call on these issues. Nonetheless, if you insist on that timing, we will do our best to accommodate your calendar. Oh man. And make ourselves available for a call on July 9th or 12th. Please let us know when will be a convenient time for you on either of those days. Oh my goodness. This is so crazy. So I wanted to see Elaine's response to that, but we don't get it. We do not get it. But it seems like it never happened, possibly. Oh, damn. Miss Brutterhoff got sent. Oh, legit email. Okay. So we already read this. Yep, Dr. Don Hughes. Interrogatories. Okay, so that's email set number 1 that are spicy. Very spicy. Between junior lawyer Sam Moniz and oh, okay. So yeah, this is a whole other thing we're not even gonna look into. Basically, this is just them fighting about whether or not they can get Johnny Depp to have a independent medical examination by someone of Team Heard's choosing, and of course, that would have been Dr. Spiegel. All right, let's find the other email. So that's spicy emails between them two. Now we read spicy emails initially between Sam and Elaine, but then Ben Chu gets involved into it, and Ben Chu